Yo, this is K-Mark Radio Live with your boy Marquel. We love law tips. Listen, we got a client on line one. Client, what's your problem? How's it going? I got just what you need. Brand new K-Mark Law Firm. You heard it here first. K-Mark Law Radio. We love you. She want that legal beagle. Case dismissed. Client's minds, fantasize, retaining me. They objecting on me. They resist this. Legal minds so refined and there when you need. Legal beagle. Case dismissed. Client's minds, fantasize, retaining me. They objecting on me. They resist this. Legal minds so refined and there when you need. I'm a country lawyer, know already. Let me stop. Thank you so much for joining us today. I am Marquel Cade with Cade Mark Law, your favorite neighborhood lawyers, back with another What Does That Mean Wednesday? It's everybody's favorite day of the week. Today, we're going to talk about public domain. I'm sure you've heard the phrase, Mickey Mouse has entered the public domain. Last year, Winnie the Pooh entered the public domain. But what does that mean? What does it mean to enter the public domain? What is the public domain? Well, today, we're gonna talk about it and you get to find out. When someone says that something has entered the public domain, they're referring to creative materials like patent drawings, songs, book characters, and these types of things that are no longer protected by copyright, trademark, patent, or any other type of intellectual property law. In effect, the creative work is actually shared by the public, hence public and public domain. A public domain work can be used by anyone at any time without prior permission from the creator of the work. And a public domain work can be used without paying any costs for licensing fees. A creative work can be considered public domain for any number of reasons, but we're going to outline 3 reasons why a work might enter the public domain. The first reason that a creative work can enter the public domain, if you will, is because their copyright expires. Currently, any work that was created before 1928 is in the public domain. This goes for characters like Mickey Mouse, Tarzan, Peter Pan, Robin Hood, King Kong. We can go on and on and on. But characters currently created before 1928 are free for anyone to use because the copyright has expired. Generally speaking, a copyright will only last for a certain period of time. And when that copyright expires, that creator's work enters the public domain. Fun fact, having a copyright expire is the most common reason that a work enters the public domain. Another reason that a work can enter the public domain is when a copyright was never requested in the first place. Before 1989, you had to register your copyright with the U.S. Copyright Office. Failure to register meant that you didn't have a copyright. So a lot of works that entered the public domain before this period or around this period are because the person who created the work didn't take the proper steps to register it with the U.S. Copyright Office. Nowadays, you don't have to worry about that. Whenever you fix your creative work to a tangible form of expression, put pen to paper, keyboard to key, those types of things, you're gonna have a creative work. And that creative work is automatically gonna have a copyright. You wanna register that copyright so that you gain the rights and the ability to sue if someone infringes, but there is no requirement for registration to gain the copyright itself. The third reason that a work can enter the public domain is when the creator of the work dedicates the work for use in the public domain. As the creator of a work, that person or entity can designate that this particular creative work is free for public use. A lot of times, I see this in circumstances where producers in my music context will offer free beats, if you will. And these instances, the producer is pretty much offering their beat for use in the public domain. So to recap, pretty much when you hear that a work has entered the public domain, this pretty much means that anyone can use it. There are no longer any intellectual property protections preventing anyone from using it. This is why we have a million movies on Peter Pan, a million movies on Robin Hood, a million movies on King Kong. These things are free for the public to use, such that any screenwriter, director, producer, movie studio can come along and say, hey, we want to adapt this property into our own creative work. They won't get protections for the character itself, but they will get protections for the new creative work, which is why you see new movies coming out and they have protections for them. By expressing the character in a new way and giving their own form of expression to the character, they may not gain protections on the character, but they'll still gain protections on what's being created. That's all, folks. Thank you so much for joining us today for another What Does That Mean Wednesday? Public domain. What does that mean? Once again, I am Markwell Cade with Cade Mark Law, your favorite neighborhood lawyers. Protect your brand, grow your business, stay frosty, my friends. We'll see you next time. We hope this was helpful.